Thank you very much, Emily, for a very interesting presentation. And I just want to draw the members' attention to the paper you got. It's a little bit broader than that, than the oral presentation, and there's a lot of valuable material in it, and I would strongly urge you to read the paper and try to understand. It's not easy for non-lawyers to understand these issues, but I would strongly urge you to read the paper. It's very useful to have it. And now we're going on to another difficult topic, and John O'Dowd is going to present to us.
Thank you very much, Judge Lafoy, and thank you very much to the members, too, for the invitation to address you today. So what I'll be talking about today is the question which came back from you, the members, about how exactly the unborn is defined, what the scope of that concept is, and also the related issue of what rights the unborn has beyond the right to life, or perhaps rights that are necessarily implicit in the right to life, such as the right to be born in a healthy and normal condition, as it's been described by Mr. Justice Cook in one case. And I want to stress, as Emily has already, that many of these are unresolved issues. They haven't been addressed by cases, and what we have to do is to try and draw out implications from the decisions the courts actually have made about the factual situations that have been presented to them. And the main case we need to grapple with in that regard is the case of Roach v. Roach, which, as the Supreme Court itself was at pains to point out, and Mr. Justice McGovern had been in the High Court as well, was not a case about abortion. It was a case about assisted reproduction. It was a case about the status of embryos that had been created outside a woman's body and not yet implanted into a woman's body. And so the case, Roach v. Roach, makes a decision about the relevance of the Constitution to that situation. Certain statements are made that might be relevant to the status of a fertilized ovum within a woman's body, created naturally, for example, but such statements are just what lawyers call obiter dicta. They are just statements of opinion by the judges, because that's not the case that they were deciding in Roach v. Roach itself. And I want to say a little bit about this question that you've raised about rights other than life, as to what range of protection is given, whether by Article 40, Section 3, subsection 3, or by some other provision of the Constitution in relation to the other rights and interests that exist before birth. So first of all, I want to say a little bit more about this notion that some things that judges say in cases are binding on later courts. So some things that are said in a judgment of the Supreme Court, the High Court and the Court of Appeal then have to follow in future cases that raise the same issue. But other things that the Supreme Court says are just by the way. They're just explanations the judges give as to why they've come to their specific decision, but they're not considered to be part of the basis of the decision itself. Therefore, they're not binding on future courts, or lower courts in particular. So not everything a judge says in his or her decision is binding on later judges. And the key issue normally in a case for identifying whether something is binding or merely an expression of opinion is whether what the judge said actually made a decisive impact on the outcome of the case. Would the case have been decided differently if the judge had thought otherwise on the particular issue where he or she has expressed an opinion? And everything else really that isn't decisive for determining which side wins in that particular case is generally regarded merely as an expression of an opinion by the judge. And I'll come back to how that distinction works in practice by reference to Roach and Roach itself. So in relation to the unborn, there may be two related questions here. Certainly that's the way this was treated in Roach, which is the general question of when does human life begin? So there might be a general issue. The Constitution protects human life, therefore you have to determine when that human life comes into existence. And then there might be a more specific issue as to what the particular phrase, the unborn, means in Article 40, Section 3, subsection 3. So Article 40, Section 3, subsection 3 talks about the right to life of the unborn, ceart na meo gan bre, chun amaha. So the right of the living who have not yet been born to their life. And judges have expressed different views about whether those are really the same issue or they're two distinct issues. So in Roach v. Roach, Mr. Justice Murray, the Chief Justice as he was then, said, really the issue isn't so much about the meaning of the term unborn in Article 40, Section 3, subsection 3. It's about whether we can say that human life has already come into existence in this condition that occurred there, that a woman's eggs had been extracted from her body and they'd been fertilized outside her body and embryos had been created in that way. So for him, the key issue was, did human life already exist? Because in his understanding of it, all the Eighth Amendment did was to make it clear that the same protection of human life that applies to everybody who's been born also applies to before birth. So from his point of view, all you had to do was determine when human life began. But I think it's clear that the other four judges in Roach felt that it really was a question of interpreting, the issue they had to decide at least, was a question of interpreting what the phrase the unborn means in Article 40, Section 3, subsection 3. So they didn't really enter into that wider question, that more fundamental question of when human life begins. And there are a number of possible starting points where a human life or the unborn could come into existence which had constitutional protection. One of them is fertilization, obviously, where the sperm and the egg are brought together and, loosely speaking, conception takes place. This is certainly what the pro-life amendment campaign wanted in 1982-83. This is what they proposed, that there should be a constitutional amendment that said explicitly that the right to life started at the point of fertilization and continued thereafter. That's not the amendment that the government responded with. That's not what the Eighth Amendment said on its face. And also, if you talk about fertilization, well, there might be a difference between an egg being fertilized in vitro outside a woman's body and an egg being fertilized within a woman's body. So, as we'll see with Roach v. Roach, it doesn't necessarily follow from saying that because fertilization has occurred outside a woman's body and that isn't human life or that isn't the unborn, that the unborn mightn't come into existence at the point of fertilization when that happens within the woman's body. You might draw a distinction between those two things. And then also in relation to implantation, the other key phase that's identified in Roach v. Roach is implantation. Again, a distinction, the same distinction basically, could be drawn between the two senses of implantation. Because in Roach v. Roach, the implantation the judges were talking about is where an ovum has been fertilized in vitro and an embryo has been cultured for a few days and is then implanted through a catheter into the woman's womb. So that's an implantation procedure, a clinical procedure which is carried out by fertility doctors. On the other hand, there's the sense in which implantation occurs in the natural process of gestation, because fertilization takes place at one end of the fallopian tube, and then the developing human life travels along the fallopian tube and implants a little bit over a week later in the wall of the uterus. So a decision that there's no unborn or there's no human life before implantation in the Roach and Roach sense doesn't necessarily mean that the same conclusion must be reached in relation to the natural process of gestation. But I'll come back to that in a moment. And then there's also a possibility which is raised by Mr. Justice, the Chief Justice's decision in his judgment in Roach v. Roach, which is that maybe the unborn only comes into existence sometime, or human life only starts sometime after implantation has occurred. But again, it seems unlikely that the courts will find that there's any point after implantation in the wall of the womb, which is the starting point of the unborn. Because it's not clear when. Clearly, any idea that viability, that the ability of the fetus to survive outside the woman's body is a decisive point, that's clearly rejected by the Eighth Amendment. If you introduced viability as defining when the unborn came into existence, you'd really be negating the whole purpose, the evident purpose of the Eighth Amendment, which is to emphasize the right to life exists even when that life isn't capable of independent existence outside a woman's body. So it seems highly unlikely the courts would find a later point than implantation which they would use to define that. So if we look at this question of the stages of reproduction, you can see here that in the natural process of gestation, fertilization takes place near the ovary, at that end of the female reproductive tract, and then there's a period of several days during which the fertilized ovum is developing, going through various developmental stages, and then finally about day 8 or day 9 it implants into the wall of the womb. So we could say implantation has taken place in those circumstances. I mention this because this is not the situation, this is not the factual situation that the Supreme Court was considering in Roche v. Roche. That's not the case they had before them. They weren't being asked to determine anything in relation to that. What they were being asked to decide was when an ovum has been fertilized in a Petri dish outside a woman's body, and the embryo has not only been allowed to develop for a few days, but then frozen and placed into storage for some indefinite period of time, and then it's thawed out and it's clinically introduced into our womb through a catheter, whether the unborn exists before that medical procedure has been carried out. And they say that in this situation, using that particular method of assisted reproduction, there is no unborn until the implantation takes place. But while that might have implications for what happens within a woman's body during the natural process of gestation, it doesn't automatically follow that future courts will consider themselves bound to reach the same conclusion. So it might be that the unborn does exist at the point of fertilization when the fertilization takes place within the woman's body. I'm stressing that because that's a question of what Roche decided. Now, it's a different question what the courts would be likely to decide if they were presented with this other question. Now, the other question, of course, so to recap on Roche v. Roche, the decision was an embryo created outside a woman's body is not amongst the unborn. Article 40, Section 3, subsection 3 does not apply in that situation. That's clearly what the court decided in Roche v. Roche, and that is binding on any High Court judge or any Court of Appeal judge. In a sense, it's also binding on the Supreme Court, and they'd have to find special reasons for refusing to follow that themselves in a future case. But they gave different reasons for reaching that conclusion. They had different ways of reaching that result. So for Chief Justice Murray, his key concern was that really it's not possible for a judge to say when human life begins, within this context at least. That's a question on which there are very profound philosophical disagreements. There are no legal criteria which would enable one to say, yes, human life has come into existence, or no, human life has not. Now, as I mentioned in the paper, of course, he was quite keen to point out that you couldn't say that at 3 months gestation, for instance, there wasn't a human life. So he thought that after a certain point, it becomes self-evident, it becomes indisputable that a human life has come into existence. But he felt that point doesn't occur before implantation in the context of the type of assisted reproduction procedure that was being carried out in Roche v. Roche. On the other hand, the other judges, 3 of the other 4 judges very explicitly say the reason why these embryos that were created outside a woman's body as part of a process of assisted reproduction are not the unborn is because the unborn only comes into existence when implantation in the womb has occurred. So the unborn only exists once it's within the womb and it's implanted in the wall of the uterus. And since that is a restrictive definition of the unborn, the particular facts of Roche v. Roche couldn't come within it. Now, that's the reason they gave, that's the reason they had for reaching their decision, but it seems fairly clear it's not necessarily binding on later courts because it wasn't the issue they had to determine. Now, what are the practical consequences of this? Well, one practical consequence perhaps is in relation to emergency hormonal contraception, commonly referred to as the morning after pill. So Levenel, I think, was the first product that the Irish Medicines Board authorized for sale. In 2002, I think the authorization finally came through. So one of the issues is about emergency hormonal contraception, and also there may be issues, although it seems less applicable, there may be issues in relation to intrauterine devices as well, IUDs. Because the argument made here is that if emergency hormonal contraception or an IUD operates to prevent the implantation of the developing entity into the wall of the womb, then that constitutes the destruction of the life of the unborn and is therefore contrary to the right to life of the unborn. So if the unborn exists, if we go back, if we backtrack, I think we can, can't we? There's the back arrow. Right. If we go back to the diagram, if the unborn comes into existence there on day 0 at the time of fertilization, and it already exists and it has constitutional protection, then if the morning after pill acts not just to prevent fertilization, but to prevent the implantation of a fertilized ovum in the wall of the womb, then that would constitute a violation of the right to life of the unborn if that fertilized ovum in the 8 or 9 days or so that it takes before implantation is the unborn. So that's the practical effect, that's the practical consequence of the decision the Supreme Court was taking in Roach v. Roach. But again, of course, they weren't considering a case of the morning after pill. That wasn't the factual situation before them. So while their opinion as to the reason they gave for their decision might have implications for that, it's not actually part of the binding decision. Now, it should be said that there's some disagreement about how often the morning after pill does operate so as to prevent implantation. If it prevents implantation, it does so incidentally because of a thickening of the mucus and the wall of the uterus. So the main purpose of the morning after pill is it's a hormonal contraceptive, but it might, as a byproduct, also in some cases where fertilization has already taken place, prevent the fertilized ovum from implanting. So the significance here is that if the unborn exists within a woman's body before the natural process of implantation, then the legality of the morning after pill or intrauterine devices would be in doubt. Now, at the time of the 2002 referendum, for example, the proposal there to put the criminal law in relation to abortion on a constitutional footing and to remove the suicide clause from the X test, that proposal was very clearly one for legislation that would confine the criminal law to unborn life within the womb. And that was one of the arguments made by its proponents, that as well as getting rid of suicide as a ground for termination of pregnancy, it was also clarifying that the criminal law, at least, wouldn't apply so as to prohibit the morning after pill, to prohibit intrauterine devices. But of course, that was an unsuccessful proposal, so that wasn't adopted in 2002. But one thing to note is that, of course, both forms of the morning after pill and intrauterine devices are authorised for sale in Ireland. The Irish Medicine Board decided to authorise Levenel firstly for sale in 2002. In 2011, it decided that such products could be dispensed without prescription in a pharmacy. Now, a challenge to this was mooted. A group announced in a press release that they were going to take a judicial review in the High Court of the Irish Medicines Board's decision to authorise Levenel on the basis that it was a violation of the right to life of the unborn, but that case has never actually occurred, so we don't have any decision on that particular question. And the other point to note is that the Protection of Life During Pregnancy Act 2013 is very specifically and clearly limited to unborn life within the womb. So the morning after pill, taking the morning after pill cannot be a criminal offence under the 2013 Act, because the 2013 Act makes it clear that the unborn life that it protects is just the unborn life that exists within the womb. And it seems most likely that that aspect of the 2013 Act is based on the assumption that the views expressed in Roach v. Roach do in fact represent the law. They represent what the Supreme Court ultimately would be likely to decide if that question arose. Because it's important to emphasize that in Roach v. Roach, at least 3 of the judges referred with approval to an English case called Smeaton, which I've mentioned in the paper, and Smeaton made the point that the old offence, the one that existed under Section 58 of the Offence Against the Person Act 1861, for example, was doing something with intent to procure miscarriage. And what Smeaton said was, you can only intend to procure miscarriage once there's already carriage, once the woman is carrying a fetus or developing life in some sense. And the English courts decided, well, the morning after pill can't be affected by Section 58, which is still in force in England and Wales. It can't be affected by Section 58 because before implantation in the wall of the womb, there's no carriage of a developing human life by the woman, which could consequently result in a miscarriage. And 3 of the judges in Roach majority of the judges specifically approve that and say that's the correct interpretation of Section 58. And also there's an element in Roach of saying, well, the purpose of the Eighth Amendment was to copper fasten Section 58 and 59 of the 1861 Act. So they're aligning the scope of the constitutional protection with the criminal law as it existed in 1983 and saying it really doesn't go any further than would be necessary to put beyond constitutional challenge and prevent the Oireachtas from repealing the provisions of the 1861 Act. But as Emily has pointed out, the 2013 Act is somewhat different in that it has a wider notion of what is involved in destroying unborn human life, but at the same time it restricts that specifically to unborn human life within the womb. And also, I suppose I should say, because Emily mentioned the question about medical treatment, it also has some implications for ectopic pregnancy, of course, because if the fertilized ovum becomes attached to some other part of the woman's body outside the womb, it seems likely on the basis of Roach v. Roach that that is not the unborn. So you're normally talking about a tubular ectopic pregnancy. That's very straightforward. There's broad agreement on how you treat that. But it would seem that a tubular ectopic pregnancy after Roach v. Roach doesn't involve consideration of treating it, doesn't involve consideration of Article 40, Section 3, subsection 3, because if it's correct that the unborn only exists within the womb, there is no unborn in the case of a tubular ectopic pregnancy. But there could be other cases, but we won't go into the details of that. So the other question that you want to know about, well, what other rights might the unborn have potentially outside Article 40, Section 3, subsection 3, or maybe another related version of that is what's the scope of the right to life that they do have under Article 40, Section 3, subsection 3. So it's true, and it's been noted in several of the cases dealing with this, that there are many laws that give children rights by reference to things that happened before they were born. So if you are in the womb and your mother is in an accident, for example, and she's injured and you're injured as well, and you are born and you have an injury as a result of something that occurred before you were born, you're entitled to sue somebody just as though the injury was caused to you after birth. But one thing to note is that generally all these are statutes that deal with what the position of a child is once the child has been born, with reference to what happened to the child before it was born. If there is no live birth, generally these provisions don't apply. They're about determining the rights of the child after birth in relation to what happened before the birth took place. And so they don't directly generally go towards, they may emphasize the continuity of unborn and born life, as Mr. Justice Humphreys mentioned in his recent decision, but they generally don't have much bearing, I think, on the question of what constitutional right, other than the right to life, the unborn might have, either under Article 40, Section 3, subsection 3, because of a wide reading of the term life, or else because there's some other provision of the Constitution that confers such a right. So the example, and Brian Murray will refer to this, I think, from another point of view in his paper later on. The specific area that's been litigated here is in relation to family rights, and particularly in the context of immigration. So basically we have a situation where we have a man who may or may not be married to the mother in question, but we have a man who is a non-national and is facing a deportation order or has had a deportation order made in relation to him. And his case is that the Minister for Justice and Equality, in deciding whether to make the deportation order or revoke the deportation order, is obliged to take into account the fact that he is going to become the father of a child once the child is born. So is the Minister obliged to take that into account? You may or may not be surprised to know that the Minister's position is, I'm not going to take that into account at all. I'll wait and see if a child is born, but I'm not going to anticipate that or try and speculate about what the future family rights might be in this situation. So there have been a number of cases here as to whether, if you have a woman who's pregnant at the time the minister is taking her decision, and there's a man who's going to be deported, who's the father of that child with which she's pregnant, the minister is obliged to take into account. Now, one thing to stress is the fact that the person concerned who's facing deportation is the father of a child is not an automatic protection against deportation. It's just a factor the minister has to take into account and weigh. So the minister might well say, no, I'm still going to deport you back to your home country because you don't have a sufficient connection with the country, or the mother and the child could go with you and live in that other country. So it's not an automatic entitlement to remain in the country, but the question is it a factor the minister should have taken into account in reaching her decision about deportation? And we have 3 cases. 2 of them say yes, in that situation where a woman is pregnant, the father, the future father, or the current father, depending on how you look at it, of her child is entitled to require that the minister give a reasoned explanation as to why his position as a father doesn't mean that deportation shouldn't be ordered in his case, because the child has a right to the society and care of his or her father when born. I suppose one thing to emphasize is that the first of those decisions, that point was conceded by the state. So the state said, we're not disputing that the minister should have taken into account the position of the father, even though the child hadn't been born yet. The second case went very strongly against that position, the decision of Mr. Justice Cook in Ukbelase. And he said there basically the 8th Amendment was very specifically focused on preventing deliberate termination of pregnancy within the state. He made the point, for example, that, as the judge referred to earlier, Article 40, Section 3, subsection 3 now consists of 3 sentences. And if you look at the sentence that the 13th Amendment put in relation to travel, he felt it would be anomalous to say that the unborn had a right to life which was sufficiently broad that it needed to be taken into account by the minister when making a decision in a case involving deportation. Because in his view, if the pregnant woman can extinguish the life of the unborn simply by exercising her freedom to travel somewhere else, that indicates that the right to life of the unborn is really only focused on what happens within the state in terms of deliberate actions taken to terminate her pregnancy. And there's nothing broader there, there's nothing wider there that, for instance, the father of the child can rely on. The most recent and the most emphatic decision we've had is the decision from last July by Mr. Justice Humphreys, where he very emphatically disagrees with Ukbelase. So you've got 2 High Court judges who disagree with each other very strongly. He's vehement in his criticism, I think it's fair to say, of Mr. Justice Cook on certain points. So he says clearly there's a continuity between born and unborn life. The minister has to take this family relationship into account between the unborn and his or her father. He also goes so far as to say that the unborn is an unborn child and is a child for the purposes of the Children's Rights Amendment, the current Article 42A of the Constitution. So he says, not only does the unborn have rights under Article 40, Section 3, subsection 3, the unborn has rights under Article 42A. It is natural and imprescriptible rights of the child that state guarantees to protect. His statement on that is a little bit undercut by him then acknowledging that, of course, Article 42A wasn't intended to have any effect on immigration proceedings. Article 42A is very carefully drafted so that it does not mean that the Minister for Justice and Equality has to take the best interests of a child into account in deciding whether to deport its parents. You'd be very surprised if the government had come forward with an amendment which did end up requiring them to take the best interests of the child into account. So it says in proceedings relating to custody of access, guardianship, etc. of the child between parents, in proceedings where the state is trying to take a child into care, in those proceedings, the best interests of the child are to be the paramount consideration. But the constitutional provision is defined very carefully, so that doesn't, at least explicitly, include proceedings about whether the child's parent ought to be deported or whether the child's parent ought to be sentenced to a long period of imprisonment, having been convicted of a criminal offence, for instance. So another thing you could say, of course, is that really, in some ways, these cases could easily be reframed as saying they're not really about the right to life of the unborn in any meaningful sense, because even Mr. Justice Humphreys himself says that the irrational thing here is that the minister is ignoring what the situation is going to be in a few weeks or a few months' time. The minister is refusing to take into account the fact that in several weeks or several months there will be a child who has a family relationship with the individual who's facing deportation. So they could be seen in an administrative law context. They're really about what it's reasonable for the minister to say he or she should take into account in making a deportation decision. They don't necessarily derive from the rights the unborn has now at this point, given that the order that Mr. Justice Humphreys made in this case was framed specifically in terms of the minister having to take into account the likely situation that was going to come into existence once the child had been born.
John, we're running over.
I'm just on my summary here, yeah?
I know, and I just mentioned that there's likely to be an appeal.
I was just about to say that.
I thought you were.
There's likely to be an appeal, and indeed it may be an appeal direct to the Supreme Court in this case that Mr. Justice Humphreys decided, because it's regarded as a matter of public importance that it be determined as quickly and as definitively as possible whether he's correct on that particular point. So in relation to summarising where we are, this is an area of great uncertainty, as Emily and the judge have already emphasised many of these topics are. There's a spectrum of views as to what Article 40, Section 3, subsection 3 does. You can read some judges, certainly, as saying that all it did was to copper fasten Section 58, 59 of the 1861 Act as they were in 1983, and to make it clear that the courts couldn't declare them to be inconsistent with the Constitution, the Oireachtas couldn't replace them with some other criminal prohibition that allowed abortion in wider circumstances. Whoops. On the other hand, there are statements which fit more easily with the actual text that was put into the Constitution, that there's an acknowledgement of a broad right to life with much wider implications in situations that are removed, that aren't directly within that context. And really, we don't yet have a decision that clearly opts for one or other of those options or finds a place somewhere in between on the spectrum, because although there are statements that are germane to that or relevant to that in Roche v. Roche, they're not binding because they're not part of the essential decision the court had to make there. Because, to recap, all the court had to decide in Roche v. Roche was whether an embryo that was created outside a woman's body was the unborn or not. So that's all they did decide insofar as settling a question for future reference. Thank you very much for your attention.
Thank you very much. Thank you very much, John. That was very, very interesting. And once again, I would urge you to read John's paper, which gives a very good perspective on the difficulty of the issues. And he deals with the cases that he has referred to, and I think you'll find it very, very useful, as you will find Emily's paper as well. We're going to have a roundtable discussion now. This will be in private. We've overrun our time somewhat, so I'm going to suggest we finish the roundtable discussion at 11:25.
Conversations chapters.